Hi, my name is John Lawless, staff attorney with Bay Area Legal Services Disaster Relief Team and the Florida Disaster Legal Aid Helpline. I'm here with my colleague Jason to discuss some simple steps anyone can take to avoid common issues while recovering from disaster. Today, we're here to talk about common issues that survivors have with construction contracts. Our discussion will be about work and contracts in Florida. So if you're watching this from elsewhere, please remember that these rules can change significantly from state to state. Many issues can arise with having work done on your home after a disaster. But today, we're going to focus on the obligations of a licensed contractor who has agreed to do work on your home. Remember that you can and should always make sure that you are hiring qualified professionals for any construction on your home. You can always verify licensing by visiting the Florida Department of Business and Professional Regulations website and clicking on Verify License. Now that we have that out of the way, let's take a look at what might happen after you enter into a contract for repairs and make a down payment. Jason, you've recently become a licensed contractor. Congratulations, Jason. Have you signed any customers? Wow, fantastic. You even remembered to give the customer a clearly visible 3-day right of rescission and left a written copy with them. Did you take any money from the customer? $640 million in bearer bonds. It looks like Jason has accepted 10% or more of the total contract price. Now that he has done that, he has some obligations to fulfill. First, Jason has to apply for any necessary permits within 30 days. Let's see what he does. Usually, we might ask for a little help from our friend, the CHRONOMANCER, but he's on vacation. So we'll just have to wait it out. It has now been 30 days. Jason, have you applied for all the necessary permits? Jason missed the deadline. Right now, his customer could write him a letter to demand that he either apply for the permit within the next 30 days or give all of the money back. We'll talk more about that in a moment. Right now, it looks like Jason is trying hard though. So let's see what would happen if he did have the permits. Now, he has 90 days to start work. It has now been 90 days since the permits were issued. Jason, have you done any work? Uh-oh. Jason still hasn't done what he needs to do. Unless Jason has a really good reason for not doing anything, his customer can write a letter demanding that he start the work or give the money back within 30 days. The customer has to send this letter if they want to take advantage of that specific law that obligates the contractor to comply. Look, there's the letter. What will it be, Jason? Will you start work or will you give the money back? Either one will do. It's been more than 30 days. Jason, why are you still here? Now that Jason has not done anything required by the letter from his customer, Jason can of course be sued by his customer. The worst news for Jason is that he can now also be charged with a crime for violating the provisions of Section 489.126 Florida statutes. For a customer who knows their rights, this can be a powerful tool to make sure their home is repaired in a timely manner. It looks like Jason is in a lot of trouble. It doesn't matter if he really meant to help the customer or not. If he violated the rules, the penalties still apply. Now, if you and your family keep these tips in mind, you'll be a lot more resilient in the aftermath of a disaster, and a lot less like Jason. We appreciate you taking the time to listen. For more information on what to do in the wake of a disaster, please visit the following resources.